Well, good morning, everyone, and welcome back to AJ111 Criminal Procedure. My name is Tony Farrar, and of course, I am your instructor for this semester. Today's lecture is going to cover Chapter 6, where we are going to look at searches and seizures of property. More specifically, we'll take a look at search warrants. I will also try to keep the lecture within the 45 to 60 minute time frame, and if for some reason I can't, I'll break it up into two shorter lectures, but I think I should be able to do that this week. So let's go ahead and jump right into our weekly lecture. So what are we going to learn this week? Well, we're going to take a look at search warrants and what they are and actually what they look like. Well, we will look at searches incident to arrest in a motor vehicle. And incident to arrest means after someone has been taken into custody, immediately following. Next, we'll look at probable cause searches of vehicles. We'll take a look at probable cause searches of containers in vehicles. So what if somebody has a smaller, like little backpack or little purse or satchel or something like that, let's say on the floorboard of the car? So we're going to look at that. We'll take a little time and look at consent searches, and then we'll finish up with other types of warrantless searches like searches of cell phones, and then finally inventory searches. And yes, there is such a thing called inventory searches. So just really quick, before we get into the Fourth Amendment, and this is a big part of what we're going to be discussing today, I want you to think about something, and I'm going to title this, Were the Police Legally Justified in Breaking Down the Door to Richard's Hotel Room? So here's a little snippet. So Officer Faro, and it's spelled Pharo in case you're just wondering, knocked on Richard's door and, responding to the query from inside the room, stated that he was a maintenance man. With the chain still on the door, Richards opened it just a little bit. And although there is some dispute as to what occurred next, Richard acknowledges that when he opened the door, he saw the man in uniform standing behind Officer Faro. He quickly slammed the door closed, and after waiting 2 or 3 seconds, the officer began kicking and ramming the door to gain entry into the locked room. Now, at trial, the officers testified that they identified themselves as police while they were kicking the door in. When they finally did break into the room, the officers caught Richards trying to escape through the window. They also found cash and cocaine hidden in plastic bags above the bathroom ceiling tiles. So I want you to kind of think a little bit about that case and what are some of the legal issues that you see in just that little snippet. And if we have time, we'll come back to it at the end. So, with that being said, taking a quick look at the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects. Remember what this says, against unreasonable searches and seizures. And that, if you go back to that little snippet I read, that's what I want you to kind of think about. So let's keep reading. Shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or persons or things to be seized. So, kind of to summarize the Fourth Amendment, yes, it forbids unreasonable search and seizure. And whether it's a warrantless search or a search warrant, it's going to require probable cause. I think we've learned that already. And we know, or we should know by now, that the exclusionary rule is based off of a couple of landmark U.S. Supreme Court cases, the first being Weeks versus United States, and the second being Mapp versus Ohio. So the main takeaway here, since we're going to be talking about searches and seizures of property, we need to understand that no warrant, specifically a search warrant, will be issued without probable cause. And I threw in this link to a video. There's a really cool video that you can find on Annenberg Classroom, and this is a link to it that really goes through the Fourth Amendment, specifically in context relating to the Mapp versus Ohio case. There's also, we talked about the Richards case, the hotel room. So again, we'll come back to that, but if you want to read a little bit more about it, I've got a link down at the bottom there, the Richardson versus Wisconsin case. Okay, so the Fourth Amendment's reasonableness clause prohibits unreasonable search and seizures, and its warrant clause proclaims what? So I'm going to kind of let that sit for just a second and let you kind of think about it. So what that warrant clause proclaims is that no warrants shall be issued but upon probable cause. And we'll talk a little bit about how you go get a search warrant, but typically the way that you do is you fill out the template of the search warrant paperwork, and I'll show you what that looks like in a little bit. And then there's an affidavit which goes with it, which is how you spell out, you basically write down all of the facts that led you up to the point where you have probable cause. And then you go to the judge, and you will swear under oath, and that's the oath or affirmation part. Just like you would in court, where you would go in to testify in a case, before you took the witness stand, you would raise your right hand. And the clerk would say, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? And you say, yes, I do. And the reason for that is because now you've taken an oath to be truthful, and you can be penalized and prosecuted if you're not. Well, the same thing stands with search warrants. Okay, so no warrants shall be issued but upon probable cause, and of course, supported by oath or affirmation. And then there's one other little piece that's in there, because if we go back and look at the Fourth Amendment, I don't want you to forget the last couple of lines. And particularly, meaning definitively, describing the place to be searched and the persons or things to be seized. Now think about it. Why would the courts want that? Why would we have to be particular? Why can't we just be a little bit general? And that's an interesting, and I'm just going to kind of let you stew on that while I continue on, and we'll come back to it in a little bit. So historically, in the U.S., the Supreme Court has expressed a definite preference for searches to be conducted with warrants based on probable cause issued by a magistrate. And think about that. Why do you think that would actually be? The court had reasoned that the question of whether there is probable cause to justify a search is really best answered by a neutral and detached person, and in this case it would be the magistrate, rather than by the police officer engaged in the often competitive enterprise of ferreting out crime. So hopefully that kind of makes sense. So what the court is kind of saying, if everything, if we had the time and we could do this, and Coolidge versus New Hampshire is one of the cases, and then there's another case to go along with it. It's Johnson v. United States. But in this case, Coolidge versus New Hampshire, the court really took a look at this and thought that, the question of whether there is probable cause to justify a search is better to be decided by somebody neutral rather than the officer who has a stake in getting the warrant. And hopefully that kind of makes sense. Because at the end of the day, it really is the balancing of interests, meaning the need to conduct the search to investigate crimes and to seize evidence of crimes and to arrest the bad guys and gals, against the interest of individual privacy. So hopefully that kind of permeates a little bit, and you kind of understand that. So in going through this chapter as we do this, keep in mind that the Supreme Court once again is engaged in the balancing of interests. In addressing the issues of searches and seizure, the court is balancing the need to conduct searches to, again, investigate crimes and seize evidence of crimes against the interest of individual privacy. Now, the warrant process has the benefit of ensuring that a magistrate or a judge determines whether the police possess probable cause to search. And this provides protection for the privacy of individuals. Now, on the other hand, and this really is true, requiring the police to obtain a warrant before undertaking every single thing they do, every search, may endanger the police and the public, and honestly, it may interfere with the investigation and prevention of crime and prove unreasonably time-consuming. So again, as we go through this chapter, consider whether the U.S. Supreme Court has struck the proper balance in defining those situations in which police are in fact authorized to conduct warrantless searches. So first, let's talk about or turn our attention to search warrants. So a little bit more kind of a review as we discuss the arrest and warrant process in Chapter 5. It is virtually the same process in obtaining a search warrant. And while all areas within the warrant are extremely important, the particularity requirement is one of most importance. And this particularity piece or requirement in the warrant must set forth the specific address to be searched and the objects that are subject of that search. And really, and this is super important to remember, because these objects will then define the scope of the search. And let me throw this out as a little teaser. So if we're looking for big, large, let's say stolen cars, can we search in somebody's drawer? Does that kind of make sense? So the object, if we're looking for smaller things, could we search a lot more areas of a home because smaller things can fit in smaller places? So again, the objects will define the overall scope of a search. And if you look on page, I think it's 164 in your textbook under table 6.1, there are several areas that are kind of defined for you or talked about what a search warrant, the parts of a search warrant. So I want to show you basically what a search warrant looks like, most of it. I mean, there's some more paperwork, but here's a copy of a search warrant, and part of it is redacted, meaning that it's blacked out so you can't see it because it is an actual search warrant. But here, this is a search warrant obtained in the county of San Bernardino, and you can see the top part here. It's got the warrant number, the seal, the place to be, some information about the affiant's name, which is the person writing the warrant, and you can see the information here. The evidence type that they're looking for, whether or not it's going to be night service. And again, it's not signed or anything because I didn't want to give too much information out, but you can see what the affidavit looks like. So this is the property to be seized component, and here is the location to be searched, any vehicles to be searched, and any persons to be searched. So that's kind of like the face of the search warrant. And then again, here's Exhibit B. This is what the officer is looking for, the evidence to be seized. All right. And then there's a separate section searching for any off-site areas like computers or sheds in the backyard or data stored on hard drives or etc. And then here, remember we talked about probable cause. Well, here's the declaration of probable cause where the officer is going to lay out the probable cause for the search warrant, the need for the search warrant. So hopefully that's just a little bit kind of a quick look at a search warrant. But here are some of the parts. So first of all, let's define what a search warrant is. So a search warrant is a court order that a magistrate or a judge issues to authorize a law enforcement officer to conduct a search of a person, location, or vehicle for evidence of a crime and to seize or confiscate that evidence that they find. And there's another component called a search warrant return, so that, just so you know, at the end of the day, after they seize the information, they leave a receipt for what has been taken, and within a period of time, the officer needs to take that evidence or the return of search warrant. They'll book the evidence into property, and they'll bring back to the court information on what they found. But let's look at some of the different components of a search warrant. Well, first of all, the first thing is the neutral and detached judicial officer. So a search warrant, again, it's an order signed by a judge that authorizes a police officer to search for specific objects or materials at a definite location. All right. And we talked about that case that was really important, that Coolidge versus New Hampshire case, where the Supreme Court held that a warrant issued by a judge is, in fact, the way that the courts would prefer things. Okay, the next part of a search warrant is the affidavit. And this is the affidavit. The warrant must be supported by a sworn affidavit which details the facts and circumstances supporting the warrant. So it spells out the information, and hopefully that kind of makes sense. So what are the facts and details to support the warrant? Next would be the probable cause statement or information. And the affidavit itself should establish that a crime has been committed and that there are objects relating to the criminal offense in a particular location. And so here again, the probable cause portion establishes that a crime has been committed and that these objects of the crime are relating to the case. They are in a particular place. And again, these objects should be described with specificity, all right, including the location will be described in specifics or specificity as well. Another little interesting tidbit, if you will, directly relating to search warrants would be something called an anticipatory warrant. So in a case called United States versus Grubbs, based on probable cause that an object not yet at the location will have arrived at the time the warrant is served, the court had approved this type of a warrant, an anticipatory warrant. So again, these warrants are based on probable cause that an object not yet at a location will have arrived at the time that the warrant is going to be served. So it's kind of an anticipatory type warrant. And here in that particular case, in that Grubbs case, Grubbs had ordered a videotape of unlawful child pornography from an undercover postal inspector, and the warrant specified that the search was going to be carried out following the arrival of the package. So you can see how sometimes or how this anticipatory warrant kind of works. Next would be the property and persons to be searched. So the federal rules of evidence state that warrants may be issued for evidence of a crime, contraband, fruits of the crime, and other illegally possessed items. Property designed or intended for use in committing a crime, or a person to be arrested, or a person who is to be lawfully restrained. So this is again the property or persons to be searched area. Next would be the particularity requirement, or more specifically, the particularity of the location to be searched. So the warrant must identify the place to be searched with what they call reasonable particularity. All right, that removes any uncertainty about the premises that are to be searched. So the location to be searched, you need to be able to identify the location to be searched in detail. The address, and maybe a garage, or the color of the letters on maybe the front of the house, or the color of the door, or the exterior stucco, and even the color of the roof. And the reason for, well, why do you think that we need to be particular? I mean, you can kind of, logically speaking, you want to make sure that you're going to serve the warrant at the correct place. So making sure the address is correct, and the number of outbuildings, like a garage or a shed, or things like that, because you don't want to search or serve a search warrant at the wrong place. And another reason that the courts want you to be particular about this, especially when it comes to the things to be seized, the need to identify those things, is because we don't want to fall back into the category of the way it used to be early on, and we're talking, a long time ago, where the British soldiers used to use what were called general searches, which means that they would just they could search any place, any time, for anything, just to find something. It was more like a fishing expedition. So that's the rationale for the particularity requirement, both for the location and for the items to be seized. So here's an example from that search warrant that I showed you earlier that talks about places to be searched. And if you look at the officer here, he says, "I request a search warrant to be issued for the premises which I have observed," meaning he saw it, "generally described as," and here's the address and the zip code. And then he further describes it: single story, single family apartment on the top floor of this complex. It has off-white stucco exterior with white trim and a red tile roof. You see how they're being descriptive? And it has an east-facing front door with a number printed on, in black writing on the door. So, and again, it should be noted that 23rd Street is an east-facing street. So you can see the description, and the reason is they don't want to go to the wrong location. They want to be very, very specific. And then additional, information, he puts in the persons to be searched and any vehicles on the property that are going to be searched. So again, here's another one with the same thing, just so you can kind of see how they describe this. Further described as a single-story, double-wide mobile home. This is a different type of a location, a residence. Gray wood panel exterior, dark gray trim, and a light gray roof. Located near the entrance of the complex. The way that it's facing. So again, you can see the specificity that are applied to these types of warrants. Same thing with the evidence to be seized. Firearms, gun cleaning paraphernalia or kits, any type of storage containers, any rental agreements here or gang paraphernalia, newspaper clippings, address, phone books, because this was a gang shooting. So they want all of that type of information. And then here, electronic monitoring devices, cell phones, pagers, etc. So you can see the specificity. So the officer's not fishing. He's looking for firearms used in a gang shooting, and then any gang paraphernalia or anything that shows residency. Okay, the next section in the search warrant would be something called staleness. A search must be carried out while the evidence is still likely to be located at a designated location. And that makes sense. And this depends on various factors, of course, including the nature of the criminal activity, because drugs are typically bought and sold relatively quickly. So it would be unreasonable to delay the search quite a long time. So if you did let's say a buy of an undercover buy of narcotics at a certain location, you wouldn't wait 30 days to serve that warrant, because chances are that stuff you were looking for may not be there. So typically, and sometimes things differ again, we've talked about this from state to state, a search must be carried out while evidence is likely to be located at a location. And typically for California, that's 10 days. And if you go past that 10-day mark, what's required by the court is they will have you go back and refresh your warrant by updating your affidavit, your probable cause, and maybe even doing another undercover buy at the location to freshen up your information. Hopefully that kind of makes sense. Time of day is the next thing listed in the search warrant. Most states and federal governments require that a search warrant be executed during the day, absent any reasonable cause to conduct the search at night. Because this is really because searches at night are typically more intrusive, or considered to be more intrusive of personal privacy. And think about this, it also increases the likelihood of a confrontation. So again, time of day. And when you look at search warrants, again, just to kind of give you an example, time of day, the officer, we left this blank because he didn't want to give away too much information, but you can ask for a night service endorsement, which is right here, which if this is checked, it authorizes the search based on information, meaning that it needs to be searched at night. So here's what the officer might be looking for. So they can, and then again, they have to sign here. But this is the time of day portion of a search warrant. Okay, next in the warrant would be the scope of the search. So the area that may be searched is defined by, again, the objects that are subject to the search. And this is a case found in United States versus Ross. So in this case, the Supreme Court observed that the search generally extends to the entire area in which the object of the search may be found, and is not limited by the possibility that separate acts of entry or opening may be required to complete the search. In other words, a warrant for a firearm provides authority to open closets, chests, and drawers and containers in which the weapon may be found. Does that make sense? Because it's smaller. But if it was a larger item, like a 50-inch big screen TV, that might be different. That would be beyond the scope of the search. And this doesn't really fit into the class perfectly, but here's we can look at this in a couple of different ways. So what if we were going to look for larger items? So let's say something that's large, like I don't know, like a small safe or something like that. It would fit into these. You could fit a small safe maybe in here, but maybe you couldn't fit it in there, so this would be precluded from being searched. All right, so this is just kind of a very broad example. I pulled it from another lesson that I teach. But if it was like small baggies of marijuana, where could you search? Probably in a lot of these places, if not all of them, right? Because you could hide small things in there. So again, the object will define the scope of the search. Next in the warrant would be the use or the possible use of electronic surveillance. Okay, and this is important to understand. So electronic surveillance is sometimes a little bit separate from what we're talking about, but in your textbook on page 166 in table 6.2, it talks about electronic surveillance. So a judge who is asked to issue a warrant for, let's say, wiretapping, eavesdropping, which means listening in, or electronic surveillance, must determine whether such action is justified, again, based on the facts submitted by the officer. So it's important to understand the requirements would be probable cause to believe that an individual is committing, has committed, or is about to commit an offense that may be the subject of electronic surveillance. Okay? Probable cause to believe that a particular communication concerning the offense will be obtained through such means, and that normal investigative procedures have been tried and they have failed, and they really do appear unlikely to proceed, or they're too dangerous. So hopefully that makes sense. So again, probable cause to believe that a very particular communication concerning the offense is going to be obtained through that electronic surveillance, and that we've already tried the normal procedures. We're looking right here. We've already tried these normal investigative tools and procedures, and they have failed. And it doesn't look like any other thing we're going to do are going to succeed, or doing this or obtaining this information through normal investigative processes are going to be too dangerous. And facilities, or the place that is used or likely to be used, has been used in connection with the commission of the offense. So again, stating that in the affidavit, the probable cause that the location that you want to surveil with electronic surveillance is used, likely to be used, has been used in connection with the commission of that particular offense. So again, there's more information on table 6.2 in your textbook. A couple of important, very applicable cases, and we're not going to have time to go over them. The first one deals with cell phone searches, which would be Riley versus California. It's a 2014 case. I have a link to the case down there. Also regarding cell phone tracking, there's some information. I have a couple of news clips from CBS News and ABC News on the issues relating to cell phone tracking, specifically what they call a stingray. And this is a mobile device that basically masquerades as a cell phone tower, So instead of having your data going to the normal cell phone tower, it'll be sucked in, if you will, by this stingray, so it intercepts it. So the question always comes down to, is that proper, and do you need a search warrant for something like that, or can you just gather data? Super interesting. And here's the big landmark case relative to cell phone tracking and searching. It's Carpenter versus United States. We don't have enough time to really go through it because we want to get back to search warrants, but I have a link to the case down at the bottom, and you can look at that as well. And here was a very interesting case. And this is where the Rialto Police Department actually put tracking devices in a cash register till on the money. And when the location was robbed, the suspects took the money, and the police department was able to track the money using these trackers back to where the individual suspects lived, and they were able to arrest them. So a really cool thing if you want to look at it. It's a really short news clip, but take a look at that. I think you'll find it pretty cool. So, okay, continuing with search warrants, let's talk a little bit about knock and notice. And sometimes they call it things different. But the English court in common law qualified the knock and notice and announce rule, or knock and announce, and basically held that if a homeowner refuses to open his or her door to the king's representative, then the sheriff was entitled to break down the door. So kind of an interesting situation. So this is, in 1603, in a case in 1603, and the case is Semaine, Semayne. So in the Semaine's case, the English common law courts pronounced that a sheriff, in serving an arrest warrant or a search warrant, is required to announce their presence and purpose for entering a home and wait to be admitted by the occupant. And the English court again qualified the knock and announce rule and held that if a homeowner refuses to open their door, that the king's representative, the sheriff, is entitled to break down the door of the house. So again, kind of an interesting concept, isn't it? Now, coming a little bit further into, current time, in another case, Wilson versus Arkansas, 1995, the special status of the home as an individual's castle, if you will, merits what we call heightened protections against governmental intrusion, meaning that we really can't just walk into your house, right? Because that would be unjust. So there needs to be some protections against governmental intrusions, and these were defined in this Wilson versus Arkansas case. So there were three explanations that are typically offered for the reason for a knock and announce rule. And the first one would be relative to violence, meaning self-defense against intruders. The second being privacy. The occupants of a home are able to prepare for the entry of police and avoid embarrassment. And then the final one would be destruction of property. And here the police are voluntarily admitted into the home and are not forced to knock down the door. So the courts have really kind of shown that there are some reasons for this knock and notice, right? It kind of makes sense. So kind of summarizing it again, in 1995 in Wilson versus Arkansas, the Supreme Court, specifically Justice Clarence Thomas, held that a reasonable search and seizure under the Fourth Amendment requires that police follow some of the long-standing common law principles of knock and notice that we just kind of talked about. So again, a really cool, interesting thing. Now, the U.S. Supreme Court followed common law, but also said that knock and notice is not required under certain circumstances, typically where those circumstances interfere with the police. So that kind of makes sense too, right? Or interferes with, let's say, the enforcement of criminal law. So in the same case, Wilson versus Arkansas, the Supreme Court listed 3 situations in which knock and announce is not required and in which it is reasonable for police to break down the door of a house. And one would be physical violence or threat of harm. The next would be prison escape. And say a prisoner escapes and then goes into a house. And the last would be that there is reason to believe that evidence will be or is being destroyed. So again, and then one other kind of little weird thing just for you to chew on, and we'll talk more about it. Police are not required to knock and announce or give knock notice when they gain entry into a home through what we call trick or misrepresentation. So let's say they dress up as someone from the electric company, and they have a warrant, but they want to get into the residence maybe through subterfuge for whatever reason, safety, etc., whatever. It wouldn't be feasible, right, for them to do knock and notice, because then they would be identified as law enforcement, right? So some kind of cool things and some very interesting things. But the Supreme Court judgment in the Wilson case raises a number of questions that the court addressed later in some different cases. And I find those actually kind of cool. But again, the police are not required to knock and announce or give knock notice when they gain entry through trick or misrepresentation. And in some states, again, it's kind of weird, the police do not have to knock and announce or give knock notice. Now, those phrases are interchangeable. Knock and announce, knock notice. It depends where you come from on the term used. But here, some states don't have to do that if the door is open. Kind of weird, huh? So in a case, Richards versus Wisconsin, the U.S. Supreme Court answered the first and second questions that were talked about. In the Richards case, the police obtained a warrant to search Richards' motel room for drugs and drug paraphernalia, and an officer dressed as a maintenance man in this case. And Richards cracked the door open and observed a uniformed officer, and realizing that the police were at the door, slammed it shut. And here the police waited 2 or 3 seconds and then kicked in the door, entered and seized the drugs. And here Richards sought to suppress the evidence on the grounds the police failed to give knock notice or knock and announce of their presence prior to breaking down the door. Again, in Richards, the Wisconsin Supreme Court upheld the search of the motel room and ruled that because drug crimes always create danger and the risk of destruction of evidence, remember one of those things we looked at, the police may enter without knock and notice and announcing their presence. So again, just there's a lot of different ways to go. So how long do you wait? And that's always been kind of a question, right? And just kind of to talk a little bit more, the U.S. Supreme Court kind of talked about a couple of interesting aspects of the Wisconsin's exception. Because here's the deal. We can talk about a couple of things here, overly broad. There's no necessity to disregard the knock and announce requirement in every instance of a search for narcotics. For example, the individuals involved in the drug trade may not be in the home at the time the police serve the warrant. And then there's other crimes. The reasons for a no-knock entry and search for drug crimes may be applied to a number of other offenses like bank robbery. So if you create some type of blanket exception, it's going to lead to other exceptions and to the eventual disappearance of the knock notice rule. And I know that's kind of a lot of legalese, but I wanted to make sure that we covered that. But again, so how long do we kind of wait? What is the standard for having to wait outside? Well, in 2003, in United States versus Banks, the Supreme Court kind of answered the question and considered how long the police must wait before breaking down the door after knocking and announcing their presence. And too brief of a waiting period would make the knock notice requirement kind of meaningless, and too lengthy of a period would risk the destruction of evidence and even allow suspects to escape or enable people inside the home to arm themselves. So this is kind of a tough case, and I have a link there where you can look at the United States versus Banks case. So in the absence of emergency or what we call exigent circumstances, the police may forcibly enter a home when the occupant's failure to admit the police fairly suggests a refusal to let them in. And again, that's still a little bit kind of gray, right? Because what about the size of the establishment? So generally, this part that I just read to you, the wait time, is also going to depend on the size of the location that you're serving a search warrant at. Because if it's a small studio apartment, that would be less time. If it's a 2-story, 5-bedroom ranch home, you might need to give a little more time. Now, the test is not how long it would take the person to reach the front door, but really it's geared more towards the time required to destroy the evidence. Again, and I know that's sometimes not very clear, but it kind of depends on the situation. So to kind of help with that, let's look at some legal equations as it relates. So here we have the knock and announce. So the police must announce their presence when executing a warrant. No knock and announce if the police have reason to believe that knocking and announcing their presence under certain circumstances would be dangerous or futile, or that it would inhibit the effective investigation of the crime, example, destroying evidence. And the time before forcibly entry, well, that varies with the circumstances, and police should not, damage property absent reasonable, suspicion that failing to act or enter will interfere with the enforcement of criminal law. So we don't want to just break somebody's door down because we can. And again, the time required for the people that are involved in criminal activity to destroy evidence, well, that kind of depends on the nature of the evidence, right? So if you're talking about drugs, that would be, you could destroy those quicker than you could destroy, let's say, a firearm. Does that kind of make sense? So it could be the type of evidence that you're dealing with. So all of these factors have to be, taken into consideration. So hopefully that kind of helps. Now, a little bit more. We're going to talk a little bit more broad. And if you want more information, by the way, on the Richards versus Wisconsin case, it's on page 169 in your textbook, and you can look at it there. So let's talk a little bit more about searches, but now what we call a search incident to an arrest, meaning after the arrest. Okay. In 1969, in a very important landmark case, Chamel versus California, the U.S. Supreme Court defined the scope or the extent of a search after an arrest or following an arrest or incident to an arrest. Okay, hopefully that kind of makes sense now. And in this case, Chamel was arrested in his home for burglary of a coin shop. And the police proceeded to search the entire house and garage and seized the coins and medals that were stolen. And Chamel, in this case, claimed that this wide-ranging search could not be justified as a search incident to an arrest. So the Supreme Court in this case held that when an individual is arrested, it is reasonable for an officer to search the person arrested, and the reason for that is because this warrantless search kind of has three different purposes. So let's take a look at that first. And again, we're still talking about the Chamel case, and this is on page 174 in your textbook. Okay, so again, the Supreme Court held that when an individual is arrested, it is reasonable for an officer to search the person arrested, right? And this warrantless search has purposes. One would be for safety, to seize weapons that may harm the officer. Two, to seize weapons that may be used to resist the arrest or flight or flee. And three, to prevent the destruction or concealment of evidence. Okay, and I have a link to the case down below. So again, we're talking about a warrantless search. And one interesting thing, again, that the Chamel case kind of showed us is that here, once again, the Supreme Court, looking at this case, kind of strikes a balance. The scope of the search incident to an arrest is carefully limited to achieve those three purposes. Now, again, a police officer, and the way the case was defined, and this is the interesting part, a police officer may search the person, but now here's like a little added piece, or the immediate area of control for weapons, contraband, or evidence. And why do you think the case that the justices in Chamel kind of added in this piece, the immediate area of control? Because we know, and we already saw, that we can search a person, their person, for safety, to prevent resistance or flight or weapons used in that flight, and to also prevent destruction of evidence. Well, now, why the immediate area? Why would that be there? Well, immediate control includes those areas from which an individual may obtain a weapon or destroy contraband. So the Supreme Court observed that a gun on a table or in a drawer in front of a person who is arrested may prove as dangerous to the arresting officer as a firearm concealed, let's say, in the clothing of the person who is arrested, right? So if I'm going to arrest you and you're sitting on the couch, kind of like how the photo shows right here, and there's a firearm in the crack of the couch, if you will, could this person easily grab that firearm? Sure. What about on the table? If there's drugs here, could they easily destroy the drugs? Could they put a gun or contraband in the cabinet? But if you go further, if those items are, say, located in a different room or even in a closet, really, unless it's for a protective sweep looking for people hiding, and we'll talk about that in a little bit, the officer really doesn't have the right to go search those places without consent or a search warrant. Does that make sense? So again, that's the immediate area rule, if you will. So hopefully that kind of clears everything up. Because the court again held that Schimmel was, properly arrested, and this is the Schimmel case. And while the police properly searched Schimmel and the area within his immediate control, they did find that there was no justification for them to search the other rooms. That kind of makes sense. So that's the rationale. You are allowed to have that immediate search area, but you can't go into those other rooms. So here's the legal equation, and I think we're going to run over on time, so I'm going to stop and break it into a second lecture. It'll be a little bit shorter, but this way you can kind of take a little break. But you have the search incident to an arrest. So you have the arrest, and you have the search of the person and area under immediate control. And if it's in a vehicle, the same thing. And one other thing that needs to happen, and we'll talk about that when we come back, is the fact contemporaneous with the arrest. All right, meaning that it has to happen contemporaneous within that time frame, immediately before or following the arrest. It can't happen like way later. All right, so hopefully that you kind of understand that. So we'll come back in a few minutes, and we'll finish off the lecture, and we'll talk about the contemporaneous requirement. So that will conclude part 1 of the Chapter 6 lecture on searches and seizure.